Hello and very good morning. Welcome to Drishti IAS. This is Dr. P Jha, and today we'll discuss a very important concept of Indian polity and constitution, that is judicial review. It is the backbone of our constitutional philosophy. It is the judicial review which empowers the citizens of this country to avail their fundamental rights. It is the judicial review which puts obligations and restrictions on the government to follow the tenets of our constitution. And also, it is the judicial review which seeks to establish a welfare government, which seeks to achieve that the executive and legislature, the other two organs of government, they are governed by rule of law, due process of law. So, the concept of judicial review that we will discuss today, it will be having 5 subsections. First, origin. Then comes meaning. What does it mean? Third, what are the constitutional provisions related to judicial review? Fourth, while applying judicial review, are there principles that our judiciary will follow? Then what is its significance and importance? And at the end, 4-5 multiple choice questions that we will be attempting. And I have selected those questions from previous year's question paper because, as I said, it is the backbone of our constitutionalism. So the origin first. It originated in 1610 in Britain in Dr. Bonham's case and pronounced by Lord Coke in 1610. Now, there is very germane question that since Britain has unwritten constitution, and in any unwritten constitution, judiciary has limited powers, because unwritten constitution bestows all powers on the parliament. That is the main characteristic of unwritten constitution. So if Britain has unwritten constitution, then how come judicial review concept originated in Britain? It was Dr. Bonham's case when Lord Coke pronounced that common law shall always prevail over House of Commons House of Commons is the lower house of British Parliament, and common law, this is the law followed in Britain and all its former colonies. You must be knowing that there are 2 types of constitutions, 2 types of laws: common law which originated in Britain, and wherever Britishers went, be it India, be it America, be it Australia, be it Canada, South Africa, wherever Britishers went, they left an imprint of common law. And these countries are still following those common law tenets and practices. But alongside common law, there is a parallel legal system that is called continental law. You find this law or this legal system in France, in Italy, in Germany, in Japan also to some extent, and other European countries also. But since the topic of today is not related to common law versus continental law, I will not go in detail of these two legal systems, but remain confined to the judicial review. Why did I say that the traces of origin of judicial review is found in Britain in 1610? Because for the first time, a British judge pronounced that prevailing law is over and above House of Commons. That is why I said that the origin can be traced in Dr. Bonham's case in 1610 in the judgment of Lord Coke. Thereafter we have American Constitution. There also we have the traces of, rather provision of judicial review, because American Constitution is a written constitution. So in America, there is a written legal provision regarding judicial review. This is the origin. Then comes the meaning. What does it mean? In simple term, it means the power of the Supreme Court and High Courts that means along with Supreme Court, High Courts also enjoy the power of JR, judicial review. It means the power of the Supreme Court and High Courts to declare a law as unconstitutional and void if it is inconsistent with any of the provisions of the Constitution to the extent of such inconsistency. Like if any law passed by Parliament or any law which is prevailing in our country that is inconsistent with any of the provisions of the Constitution, then Supreme Court and High Court has the authority to declare that law as unconstitutional. This is the meaning of judicial review. Judicial means judiciary, review means revisit. What does that mean? It simply means laws passed by Parliament or actions taken by the executive both can be reviewed or both can be revisited, both by Supreme Court or High Court. That is judicial review. Supreme Court and High Courts can revisit these laws, these actions, to assess and evaluate that are they in sync with constitutional provisions, and if it is found that they are inconsistent with any provision of the Constitution, then Supreme Court and High Court both have the authority to declare that law passed by Parliament or action taken by the executive as unconstitutional and void. This is the meaning of JR. It also means that Supreme Court and High Courts, they have the power of judicial review against both legislature means Parliament of India and legislatures of each of the states plus executive. That means the Supreme Court and High Courts can declare not only the acts passed by legislature, but they can declare any action taken by the executive as unconstitutional and void if those laws or those actions are inconsistent with any of the provisions of the Constitution. So thereby, this power is available to the Supreme Court and High Courts against both legislature and executive. Now the point is, what is the constitutional basis of the power of judicial review? Actually, there is no article on JR. That is what it is written here. The provision of JR, judicial review, is not explicitly mentioned in the Constitution. There is no specific article which talks about JR. But there are multiple articles which give power to the Supreme Court or High Courts, and from where we derive that Supreme Court and High Courts, they enjoy the power of JR. But so far as articles are concerned, there is no specific mentioning of JR. So if you are asked in the examination that which article talks about JR, there is no specific article on JR. Having said that, what are those articles? First one, we have Article 13, which confers this power on Supreme Court and High Courts. Article 13 defines law. If you look at Article 13(3), you find the definition of law. Any order, if you look at the phrasing of Article 13(3), it says, law is defined as including an ordinance, order, bylaw, rule, regulation, notification, custom, or uses. Everything is law. So there are following components of law. First is ordinance. Then you have order. Then you have bylaw. Then you have notification. Then you have rule, regulation. Then you have custom. Then you have uses. You will see the significance of these words that I have just written. So it says, all these are law. This is 13(3). Now, look at Article 13(1) and 13(2). 13(1) talks about pre-constitutional law. And 13.2 talks about post constitutional law. 13.1 says that prior to the commencement of Indian Constitution, that is prior to 26th January 1950, if there is any law which is prevailing in our country, if that law is inconsistent with any of the fundamental rights, then that law shall be declared as unconstitutional and void. That means any law made by the Britishers, any custom prevailing in our country, any uses being followed in our country, if those laws, customs and usages are inconsistent with any of the fundamental rights, then Supreme Court and High Courts have the power and authority to declare that law, that custom, that uses as unconstitutional and void. And 13.2 says Parliament or legislature cannot make any law, that means post 26th January 1950, legislature at union and legislature at states cannot make any law which goes inconsistent with any fundamental rights. If it is so, then Supreme Court and High Courts have the authority to declare that law as unconstitutional and void. What does that mean? It means regarding JR, so far as fundamental rights are concerned, the power of JR is explicit under Article 13. And the same power for rest of the Constitution, it is under Article 32 for Supreme Court, Article 226 for High Courts, and there is a very important article, that is 142, Supreme Court. So these 4 articles, they give the power of judicial review to the Supreme Court and High Courts. Otherwise, so far as judicial review is concerned, there is no explicit article on JR. Hopefully I am clear. So friends, from these 4 articles we infer and we derive the power of JR available to the Supreme Court and High Courts. Now, the next segment is, what are those principles that is followed by the judiciary? Is it arbitrary and no safeguard available? No, there are certain principles that judiciary must follow. It is not an arbitrary power available to the judiciary. Rather, there are well-established principles that must be followed. First principle is no remedy or alternative shall be suggested. Like suppose Supreme Court and High Courts, they declare any law passed by the legislature or any act done by the executive as unconstitutional, suppose, then Supreme Court or High Courts won't suggest any remedy. It is up to the legislature or up to the executive to rectify the inconsistency. Judiciary won't suggest any remedy. It can only say that this law is inconsistent with this provision of the Constitution, hence it is unconstitutional. But no remedy, no alternative shall be suggested, otherwise it will violate separation of power. So this is the first principle. Second principle, suppose any law passed by the legislature or any act done by the executive there are two interpretations. First, according to first interpretation, that law or that action seems valid, and according to second interpretation, that law or action appears as invalid. In that case, judiciary will declare that act as valid. Say, for example, any law passed by the Parliament has been challenged in the Supreme Court on the ground that it violates privacy. But government argues that India is a developing country, India is facing multiple security threats, hence government needs such powers. There are so many terrorist attacks and there are so many anti-national activities going on. So government needs this power to actually face those challenges. So here a law has two interpretations. One interpretation says government needs those powers given the kind of circumstances we are facing. That means first interpretation says that this law is not inconsistent, rather it is required. But second interpretation says it violates Article 19, Article 21 or right to privacy. So if any such situation arises, then Supreme Court will go by first interpretation and declare that law as valid. If I have to summarize, if a law has two interpretations, one interpretation makes it valid, second interpretation makes it invalid, then while applying judicial review, the judiciary shall go for the first interpretation. Third, JR shall not be applied unless law comes into force. It simply means, suppose a bill has been introduced in the Parliament, it has not yet been passed, it has not yet been assented to by the President, then you cannot challenge it in the Supreme Court. A law can be challenged only when that law has been duly passed by the Parliament, it has been assented to by the President, it has been notified by the Government of India, then only you can challenge. If Parliament is debating on something, that cannot be challenged. So this is the third principle of judicial review. Fourth principle is reference or petition is needed. It means judiciary cannot take up any matter for judicial review so motu. You need a reference to be made. You need a petition to be filed in front of the court. Then only JR can be applied. So these are the four principles of judicial review. It is not an arbitrary power available to the judiciary. These are four principles which are to be followed while applying judicial review. And last segment of JR is importance. It is the judicial review which enforces the concept of limited governance. It is the judicial review which reminds the government of its responsibility. It protects individual liberty, and it is the judicial review which legitimizes government action. And at the same time, it prevents the government from becoming totalitarian and imposes the concept of limited governance on the government. Because government is limited by the constitutional morality, constitutionalism. Government cannot become despotic. Government has to be mindful of its responsibilities. And that is why I said it is the judicial review which imposes the concept of limited governance. Because in any democratic constitution, the government is subjected to, in its functioning, to the doctrine of limited governance. It upholds the supremacy of FR, and that is why in Minerva Mills case, (1980), Supreme Court declared that JR, judicial review, is part of theory of basic structure. It itself signifies the importance of judicial review. Because when Supreme Court realized the importance of JR, and no government can amend it, no government can take away the judicial review even by means of an amendment, Supreme Court declared that judicial review is part of theory of basic structure. That means now JR cannot be amended, cannot be taken away. That highlights the importance of judicial review. And the last segment, friends, we have this question answer. The first question, consider the following statements with regard to pardoning power of the President of India. The exercise of this power by the President can be subjected to limited judicial review. So this statement is correct. The President can exercise this power without the advice of the central government. This is not correct, because it is Article 74 which says that President shall act as per the aid and advice of the Council of Ministers. So here first statement is correct, answer is A. Then we have consider the following statements The Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights, and democracy. Correct? The Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. Both statements are correct, so answer is C. Third, consider the following statements. The 44th Amendment to the Constitution of India introduced an article placing the election of the Prime Minister beyond judicial review. Now, this statement is incorrect because it is not 44th Amendment, it is 39th Amendment. So, first statement is incorrect. Second, the Supreme Court of India struck down the 99th Amendment to the Constitution of India as being violative of the independence of judiciary. This statement is correct because 99th Amendment pertains to National Judicial Appointments Commission. So, second statement is correct. Answer is B for Bombay. Fourth, in India, judicial review implies the power of the judiciary to pronounce upon the constitutionality of laws and executive orders. Absolutely correct. So, first statement is correct. Hence, no need to even look at other options. And last is, the Indian parliamentary system is different from the British parliamentary system in that India has both a real and nominal executive. Incorrect. A system of collective responsibility in Britain also. Bicameral legislature in Britain also. System of judicial review. Because India has a written constitution, Britain has unwritten constitution, and judicial review is an essential ingredient of written constitution, right? So thereby we completed today a quick run on a very important concept of judicial review. Thank you so very much. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.